like each of you, starting with you, Holly, if you would give me the key takeaways that you'd like to see practitioners leave today's webinar with.
Yes, I think what I tried to drive home in my presentation was just kind of understanding who is a fiduciary and the responsibility that comes with being a fiduciary. I mean, there's certain times where we'll have clients where they don't have a committee set up, so we always suggest that. Or like I said, I mentioned one time I joined a board and no one had ever asked the question, is someone concerned with, what the fees were being charged in our 401k plan? So just understanding, your responsibility and making sure that you're fulfilling that responsibility in a way that's going to come through if the Department of Labor or the IRS were to ever audit your organization.
All right, let's move on to you, Janine Marasciullo.
I think for the people who are working with broker-dealers, registered investment advisors, and other financial institutions that are dealing with owners of individual retirement accounts, they shouldn't take too much comfort in the Fifth Circuit decision in vacating the rule. I think that FINRA and state regulators and the SEC are going to be taking hard looks at rollover transactions. That doesn't mean that they should forego the opportunity to work with individual retirement investors. They should take a look, even if you're not registered. If you're with a registered investment advisor that's not subject to regulation by FINRA, but you are subject to regulation by the SEC, or a state regulator, I would recommend you take a look at FINRA Notice 1345 because it lays out the kinds of things that you should be documenting when you are working with investors who are considering rolling plan assets into an individual retirement account. And, Rachel made the point that the best defense to any litigation is creating a good record of your efforts to meet your obligations. And FINRA has given a fairly good roadmap to broker-dealers, registered representatives, and others who are working with investors in this area in terms of what factors should be looked at. And again, I think that one of the big issues is going to be, is the individual retirement account more expensive than an employer account? Or an employer plan, or are there going to be some drawbacks? And again, those might be there, but there might be other very good reasons to roll over into an individual retirement account, and as long as those are documented, you should be able to protect yourself.
Rachel Markin, you get the last word.
Thanks. A fiduciary wrestling with compliance, the uncertainty of the fiduciary rule, or ERISA's general standards should remember the terminology that the courts have used across ERISA claims of procedural prudence. What were the procedures followed? Did you have procedures? Did you follow your own procedures? Can you establish through documentation and memory that those procedures were filed? That's the best protection for fiduciaries in this uncertain environment.